this matter has not become moot? Is this matter not moot? If, in fact, she has moved on.
It hasn't.
Would a determination by this court have any meaningful impact?
It has, my lords and ladies. The court always stays away from giving judgment full time. More particular, this court acquires judgment came far before all these things happened. So that judgment still stands as it was delivered.
That's not the point, Mr. Mfungura. The point is this. Two things have happened, both from your, and you accept them, they're undisputed, they're common cause. Firstly, the third respondent, Thokozani Khupe, is no longer, well, she has her own wing of the MDC, does she not?
I will not be qualified to answer for her.
Well, is she a member of the MDC-A, of the MDC Alliance?
My lord, I have no instructions. I profess ignorance to that question.
So you're not prepared to deal with this aspect? You can't. If you say you can't answer that question, you're in no position to deal with whether or not it's become moot. Because it's a critical question. Perhaps it's for counsel for the third respondent to deal with. Perhaps you should say that instead of trying to answer the question.
My lord, to answer that question, the third respondent is here protecting. To that extent, she is associating herself with the MDC that was formed in 1999. To that extent, she is part and parcel of that MDC. To that extent, I can answer. That's why she was fighting the battle to be here also. So it cannot be moot because she's part and parcel of this appeal today. If she had moved on, she would not have been here. She would have said, do your things. But she's here.
Second aspect is this. You say that the second appellant, Nelson Chamisa, was elected at a Congress in May or June this year. Is that right?
It's correct.
Your argument probably is that that was not a proper Congress, but for whatever reason, the essence of your position in the court a quo and the essence of the judgment a quo was that the appointments of Nelson Chamisa as deputy president and as acting president were unconstitutional for the principal reason that he was not elected.
That's correct.
Now that he is elected, does that not change the entire situation? Does not the whole question become moot?
They are not, my lord, with respect. I will answer it in this manner.
What do you want to say? It was not the MDCT which held that Congress. That's what you are saying.
That's the answer. That's the answer. Not only that, but my lord, it's common cause also, my lord, that whatever they were doing, relying on this constitution, had nothing to do with the owners of this constitution. So whatever they did, they were doing their own thing somewhere.
So who is the owner of this constitution?
I believe now, my lord in late, the status quo of 2014, which progressed until the death of Dr. Richard Mugen Changirai, are the owners with the hierarchy that is found in our founding affidavit, that the leadership is number one, Deputy President Thokozani Khupe, number two, Chairman, after the resignation of, I believe, Komichi rightfully so became the chairperson, number three, Douglas Monzora, as the Secretary General. These are the owners of the Constitution. And before disposing the clauses of their Constitution, they cannot be made redundant. So this court is not dealing with the moot question. It's dealing with the real and substantial issues.
So what you're saying basically is that everything need to go back to the time immediately after the death of
That's correct, my lord.
of Morgan Changa.
That's very correct. And we so pray.
Thank you, Mr. Mutungura. Mr. Madugu.
My lords and my lady, my address is in 4 parts. I just want to guide the court how I intend to proceed. I'll start with the issue relating to deputy presidents. And then the second issue, I'll address the meeting of 15 February 2018. Then the third is to address various matters, I'll call them various matters that my learned friend has already addressed, just to add a few points if I have the time to deal with that. This will be matters to do with whether the first appellant was properly barred. That's an example under that third point. Then the fourth one would be the appropriate order that we would seek, which will relate to the issues that the court has already raised relating to whether or not there is anything moot. So I will follow those 4 positions. Now I relate first to the issue relating to the deputy president. My lords and my lady, I respectfully submit that the court was correct in holding that the constitution of the first appellant does not provide for more than 1 deputy president. The position that I will seek to address is that in terms of the constitution of the Movement for Democratic Change, properly construed, there can only be 1 deputy president. Now, I start from the premise that there are 2 provisions where there is reference to deputy presidents in the plural. And here, my lords and my lady, it's clear that we are using 1 constitution. The documents before you, they are identical. The only difference being that one is signed by the late Dr. Tsvangirai. But that's the provision I refer to. The first provision that relates to deputy presidents is the provision 6441, which is on page 29 of the Constitution. What that provision simply says that the following officers are elected by Congress. Then it mentions deputy presidents.
29 of?
Page 29 of the, not of the record, I'm sorry, my lord. It's page 29, it's page 29 of the record.
Of the record?
No, we're looking at this, what I call the authentic testament.
Authentic one.
You are referring to the record?
I'm referring to, but I need to be with the court. Let's refer to the authentic document. That would be on page 15. And yeah, page 15. And then, yeah, that's page 15. Which says that the National Standing Committee shall compose of the following office bearers elected by Congress. And then there's a B that provides for deputy presidents. Then the next provision is on page 17 of that authentic Constitution is 653. Which says that the National Executive Committee shall be composed of the following office bearers and secretaries Then it has A, president and deputy presidents. That's on page 17. Now, my lords and my lady, those are the only two circumstances where this constitution refers to deputy presidents. There is nowhere else in the constitution where you have any reference to deputy presidents. Now, there are several portions that actually refer to one deputy president. And I will respectively submit that those sections refer to what one would see as the substantive provisions. I will start with clause 9.2, which is on page 56. Of the authentic constitution. The clause is 9.2. It's very clear, this whole section deals with the office bearers. That's the Article 9 has a very clear title, office bearers, National Council, and their election procedures. It's clearly labeled, here are the office bearers of the party. And the first one is 9.1, that is the president. Then 9.2, deputy president. It's in the singular. It shall be the duty of the deputy president. Then it goes on to, it's listed there. Clearly that showing that what this constitution has in mind is one deputy president. That is the first reference. Now, one would have expected that if you are providing for deputy presidents, you would indicate that they are deputy presidents. But that's the first one. The second one, my lords and my lady, is 9.3, which is on the same page, page 56. That is under national chairperson. 9.31a says that, I will read it, it shall be the duty of the national chairperson, A, to perform the duties of the president's office in the event that both the president and deputy president are unable to perform the functions of the president's office. So it refers to one deputy president again. But here we are dealing, my lords and my ladies, with substantive provisions of the Constitution. Then that takes me to the third important reference. My lords and my ladies, that is 9211, that is on page 64. On page 64, Article 9.21. That's on page 64. At 9.211 is the important article that refers to the death of the president or resignation. It is clear the deputy president assumes the role of acting president. That is the third reference to deputy president in the substantive provisions of the Constitution. Then the fourth, my lords and my ladies, the fourth one is 10.16. This is on page 69 of the authentic Constitution. Page 69 of the authentic Constitution. And that is 10.16.1. It says there, it provides for committees. There shall be an advocates committee whose members are as follows. A, the deputy president as chairperson. Now, my lords and my ladies, if one looks at this constitution and takes into account the principles that I've outlined in the heads relating to the interpretation of constitutions of this nature, we take a benevolent, common sense approach. You have a detailed constitution that is very careful. You don't just create an office just for the sake of creating it. You create it to give it responsibilities. And somewhat, when you are dealing with the responsibilities of that office, you forget that you actually have more than one deputy president. Some of them are very critical. I mean, how do you chair the advocates committee? If one looks at that last example I've given, this is the person who chairs a committee that deals with what is called international re-engagement. And how else do you provide for which vice president would chair that committee if you have more than one? The same applies to the provisions relating to who takes over in the event of death of the president. A very specific provisions. The conclusion that I respectively urge the court to take is that on a proper interpretation of this constitution, there is no provision for more than one deputy president. My lords and my ladies, that is not all. We now know as a fact that there was only one deputy president elected at the Congress in 2014. And there's no question about that. It's accepted that one deputy president was elected at that Congress. More in line with these provisions that are substantive. The only point that the appellants seek to one the court to set aside the decision of the court of court is simply that there is an S in these two provisions. That point was addressed by the court of court. That would not be a sufficient basis. The basis is clear that the Constitution contemplates one deputy president by its own provisions. This, I want to get more to say after the four provisions I referred to, and then one point additional is that there is one election that took place, one person was elected. But the other point I wish to add is that if you provide for deputy presidents, common sense suggests that you would indicate whether there are 2, there are 3, there are 4, there are 5. You cannot have a constitution that says there shall be deputy presidents. It doesn't tell you how many they are going to be. More clearly showing that that would be in line with the court of court's interpretation that this is a typographical error. And I will address that point, bearing in mind that Advocate Mpofu has made some submissions in relation to the typographical error point that the court of court made. But my point, my lords and my ladies, is that this constitution does not provide for more than one deputy president. We only have one deputy president elected at the last Congress in 2014, and that is the deputy president who is referred to in Article 9.21, who becomes acting president upon the death of the president. Now, I wish just to address the last point on the typographical error. The point that has been made before you, my lords and my ladies, that the court ought to have received evidence or ought to have considered evidence. That is simply an incorrect position of the law. The conclusion that there is a typographical error is a conclusion of law. It's a principle of interpretation. It's equivalent to a court that says it was never the intention of Parliament. You don't say go to Parliament and get the evidence that Parliament never intended to do so. It's an interpretation principle. A court is faced with the provisions that I have laid out, my lords and my ladies. And the court must come to a conclusion. Do we have one deputy president or we have more than one? The court looks at everything and says, surely the totality of this constitution is that there is one deputy president, and that other S could only have been a typographical error. That conclusion, my lords and my ladies, is a conclusion on the law. It's an interpretation method where you you say the framers would not have intended. The framers may have made a mistake. So there is no law that, it is not the law that where a court wishes to reach a conclusion, it must call for evidence. So that would be my conclusion in respect of the issue, does this party have one deputy president or more than one deputy president? Now, alternatively, my lords and my ladies, even if one were to accept that there would be more than one deputy president, surely the Constitution is clear that those deputy presidents ought to be elected by Congress. That's very clear. And I'm moving on to just to complete on that. They ought to have been elected by the deputy president. But a suggestion has been made that indeed the late Dr. Changirai had the powers to appoint his own deputy. That's the point that has been made. My lords and my ladies, I might have not the appropriate word to respond to that. But I would rather use the word strange. I would pick on that word. It would be very strange to say that the president would have the power to appoint his deputy. Why is it strange? It is strange because a deputy president has serious responsibilities in terms of 9.2, which is on page 56. 9.2. That's on page 56. That is the other phrase I've referred to earlier on, 9.2 on page 56. This is the person who will act on behalf of the president. This is the person who would assist the president. This is the person who takes over. Surely, if one looks at the complete picture of the constitution of this party, we will assume that it is a democratic party. It says so in its opening remarks. You have the top officer who is the president and his deputy. These are persons that are running an entire organization. Now, why I would emphasize that it is strange is that the president never says that he has the power to appoint the Secretary General. He cannot appoint the national chairperson. He cannot appoint the national organizer. All these persons, he cannot appoint them. As Congress, in its wisdom, in terms of its constitution, would certainly want these officers to derive their legitimacy from the electorate, which is the Congress itself. Now, why would it be possible for the president to appoint a deputy president when he cannot appoint the Secretary General? He cannot appoint the national chairman. He is given the right to appoint deputies. So if one gives that interpretation, it would be to totally undermine the office of deputy president. This is a possible president in the event of resignation, a possible president in the event of the unknown death, like what has happened. It's a person who must derive their authority directly from Congress. My lords and my ladies, the Constitution says so. That's where we are. It says that these officers are elected by Congress. You cannot interpret that provision 914 to mean that the president may appoint any of this, because the Constitution is very specific if there is no other provision in there. So I conclude with respect, my lords and my ladies, that first, one deputy president. If alternatively, if that doesn't find favor with the court.
Perhaps before you wind up, if you can also comment on 914. That's still on page 56.
Yes, thank you,
The provision that gives the president the power to appoint deputies to officers of Congress.
Thank you, my lord. That is the provision I am already attacking, in the sense that that provision must be restricted to officers whose coming into office is not otherwise provided for in the Constitution. And it says so there, the power of the president to act under 914 is where such is provided for in this Constitution. So it would be absurd to say that you use 914 to appoint your deputy president when the Constitution specifically lists who the officers of Congress are. It is clear, if I may take the court to say that when one has special regard to the deputies there, this Constitution lists what the officers of Congress are. In just bear with me, in 6441, that clause on page 15.
Relating to the Secretary for Elections.
Correct, that's in election. But also if one looks at that provision, I want to take the court to that page 15, just to make the point in answer to the question by my Lord Justice Garu. It says that the National Standing Committee shall compose of the following office bearers elected by Congress. Then it lists the president, deputy presidents, the national chairperson. Then there is the deputy national chairperson, who is actually supposed to be elected by Congress as well. The Secretary General, and then we go on to that. It would be ridiculous to use 914 for the president to appoint another deputy national chairperson. Because then you can, that's the same argument. The only difference that there's no S under D. If there had been another typographical error, we would have had the deputy national chairpersons. Then the president would say, this one was elected at Congress. Then he comes up with perhaps 5 deputy national chairpersons. Because we don't know where he got the 2 and not 4. Now my submission with respect, my lords and my ladies, that 914 cannot be understood to give the president powers to appoint persons that ought to be elected. That's my submission. The Constitution says these we elect, and where it wants the president to appoint, it will appoint. If I may get perhaps 10 more minutes. So I think I should close on that. My point has been made, my lords and my ladies, unless there would be. The point being that the suggestion given that this appointment was lawful would be bad, but I shouldn't finish without saying that the late Dr. Changira himself doesn't even say that he's exercising powers in terms of, he is undermining an elected position. He says in his affidavit that I was asked or directed to appoint, and I did so. And somewhat interestingly, he doesn't at all tell us that there was a specific amendment that increased the number of deputy presidents from 1 to 2 or 3. He doesn't say that. Because what this constitution does say at the opening, where this signature, it tells us that this party has been around since January 2000. And there were several amendments. But it's also agreed, I think in all submissions, I'm sure Advocate will accept, that the issue of deputy presidents being more than one only arose with the appointments of the 2 vice presidents who were appointed in 2016, meaning that there ought to have been an amendment. And I would draw the court's attention to the fact that in this authentic document, we have various footnotes that tend to show that there's an indication that this amendment took place at such a particular time, which doesn't arise with the issues related to the deputy president. So there was never an amendment, and there's no provision for that. So the conclusion is inescapable that the appointments of the second appellant and the other deputy presidents was unlawful, that and null and void. Then I come now to the issue relating to the meeting of 15 February.
Just before you move on, Professor Maduka, perhaps you'd like to just deal quickly with Article 18.
Thank you, my lady. Article 18 relates to powers of the National Council. Not necessarily, but specifically that where there are oversights and omissions, then the National Council may act in terms of Article 18. But this article is very specific. It would not arise if there is already a specific provision. It would not arise to deal with filling the position of deputy president when the position has already been filled by Congress. So it would depend on, we can only address Article 18 if we were to come to the conclusion that there were indeed there is a provision for vice presidents, but there is no provision for how they ought to come in. But that can't arise because the Constitution says whether there are 2 or 3 or 4 vice presidents, they ought to be elected by Congress. So there's no omission or oversight. Or there's nothing in Article 18 that would call for a National Council exercising any of the powers there. It doesn't arise in the circumstance of this case. That would be my answer to that. But further to it, my lady, it was also going to come under my now next point, and let me make it now. The National Council, when it seeks to exercise the powers in Article 18, ought to be properly called for that purpose. You cannot just find yourself together by accident, and you look around and you see that you are members of the National Council. And then you go to the corner and then start exercising the powers under Article 18. You ought to be properly convened, and that you are going, the agenda of the meeting must be specific, that we are meeting. One of the items is that we will be called upon to exercise our powers under Article 18. And it must be clear which oversight.
Sorry, which date was this meeting?
This meeting was
the
on
National Council?
The National Council was on 15 February 2018.
Same one?
What?
The same meeting that we've been referred to all this time. I'm saying the appointment of the deputy presidents. What are we talking about? Appointment of deputy presidents or appointment of acting president? Which one?
Well, I think I was answering in relation to the appointment of the acting president.
You seem to be straddling both. We need to be clear.
Yes, I'm indebted to that point. My lord and my lady, we have no minutes on record as to what happened at the meeting that the late Dr. Tsvangirai is referring to. So we cannot tell what happened at that meeting, which would have led the National Council to exercise that power. He doesn't say it because what we have on record affects where he simply says that I was directed. He doesn't say that he was directed pursuant to Article 18, or I was directed because we had seen an omission that we had not made provision for the election. So it won't be helpful to look at, to rely on Article 18. That would be my answer, Justice Patel, to that. I now wish to get to the meeting of 15 February 2018. My lords and my lady, this meeting was held within a few hours of the death of the late Dr. Tsvangirai. By the time the meeting was held, the party already had an acting president by virtue of Article 9211. In terms of the Constitution, only that acting president could have convened a meeting of the National Council. That arises under the powers of the president. That is under 9.1.21. It's on page 55 of the authentic Constitution. 9.1.2.1. It is the one that tells us that notwithstanding any power elsewhere, the president shall convene any extraordinary meeting of council, congress, or national council, the national executive. It specifies. A meeting can only be validly convened if it is convened by the person with authority. Now, my learned friend, Advocate Mpofu, was asked who convened the meeting of 15 February 2018. I think, with due respect, he was unable to tell us who convened that meeting. He made reference to the minutes, which claim that there had been a proper notice. That is on page 116 of the record. It doesn't say by whom that proper notice was sent. But yet that is also, my lords and my lady, contradictory in the sense that we are told in that document that this meeting had already been convened before the passing on of the late Dr. Changira. So it could not have had the agenda of discussing the issue of an acting president. And then how a meeting of that nature with an agenda that, obviously that agenda would not have been about the death of the president if it was convened before. Now, how do you change the agenda of a meeting, of a body of that nature? And any reading through the minutes show that it appears that these people came for a funeral, and then they converted that meeting. Because that's when, if you go through everything, it's all about what he said through and through. Even when the second appellant turns up on page 118, he indicates that the purpose of the meeting was to communicate to the members that the president had died. But what I find important, my lords and my lady, is that the second appellant is already described as the acting president in that set of documents. He starts as acting president. So never mind with respect to the issues relating to who was chairing, although the document says he was chairing. And throughout he's described as the acting president. But the Constitution provides for an acting president, who is the third respondent in terms of 921. So my submission in respect of this meeting is that that meeting was invalid. It could not have made the decisions it purportedly made because that was contrary to the Constitution. Then I turn to the last few things, I hope I get time to do that, which relate to whether the first appellant was properly barred. I submit that the first appellant was properly barred in the court on the authority of the Madzivire case. And here I draw attention of the court to page 137 of the record. Page 137 of the record. Where Mr. Komich there tells us the basis upon which he was deposing to this affidavit. He says there, that's on page 137, I am duly authorized to deposit this affidavit in my capacity as national chairman. That's what he said. So he's suggesting that his authority comes from nowhere else except from the office of the national chairman. He doesn't say that he was authorized by some committee to respond to the proceedings that were before the court. Now, the law is very clear, my lords and my lady. And here I'm answering directly to what my learned friend, Advocate Mpofu, said. He says that you cannot take me to court and then tell me that I'm not suited. But that's what the law exactly says. Even where you are sued as a respondent, and if you are sued in your capacity as a board corporate, there ought to be authority for that. And this is in the Madzivire case. But there's a recent judgment by my Lord Justice Garwe, which is judgment number 73 of 2019. That case is Cuthbert Dube versus Premier Service Medical Aid Society, SC 73 of 2019. The judgment, my lords and my lady, was handed down on 19 September 2019. There, His Lordship explains that if you are a board corporate, it's not enough for you to simply say, I have authority by virtue of the office. And in that particular case, it was a managing director. That's the highest office you can ever have, who says, because I'm managing director, by virtue of that office, I am authorized. And the court came to the conclusion that there was no opposition. That answers directly to the question that is an applicant can object. In this case, there was objection in the answering affidavit. It was incumbent upon Mr. Comich to have produced the authorization once it was challenged. But this also takes me to the fact that it doesn't take that point any further, because even if that is the conclusion of the court, there will be no basis for setting aside the decision of the court merely on account of the first appellant not having been heard. Because the first appellant was heard. This only arose in the context of the judgment of the court. Mr. Comich presented on behalf of the first appellant. They were heard. When judgment time came, the judge said it was not properly, it was bad. And so there's no point in challenging the decision of the court on the simple basis that the first appellant was not heard. They were heard. This is only if one says that they were improperly bad. But our submission is that they were properly, the first appellant was properly bad for submissions I have made. And then I rushed through the domestic remedies. May I refer the court just to, in addition to the case of Forestry Commission, Moyo versus Forestry Commission. Moyo versus Forestry Commission is 1996, Volume 1, Zimbabwe Law Reports 173. At page 192, it's a judgment then by the current Chief Justice, but then he was still in the High Court. But this is a clear summary of our law, that there will be no point in invoking domestic remedies when it is clear that they have been undermined. And that's what my learned friend for the first respondent has said. That if we look at the circumstances surrounding what happened on 15 February, it would be very unrealistic for any court to say that there were any domestic remedies to refer to. This party had been taken over by the persons that met on 15 February. And so there's no domestic remedy to talk about. But more fundamentally, my lords and my lady, the decision by the court, the reasoning of the court was simply the exercise of a discretion. Were the domestic remedies available, or were they an appropriate remedy? The court exercised the discretion and came to the conclusion that they were not. And there's been nothing that has been placed before you to say that that discretion was improperly exercised. And in this regard, my lords, I have to ask your forgiveness. It is a case that I don't have full citation. It's the Cargo Carriers case. It's a 1996 decision by this court. Cargo Carriers. It will be 1996. I'm sure my lords, my ladies here assisting the judges will be able to find that case. The judgment is by 1996. Judgment by the then Chief Justice Gabe, where he says that the issue of a domestic remedy is really within the discretion of a court. Decides whether it will entertain or not entertain. In this case, that discretion was exercised. And the reading of the judgment of the court shows that the court was very much alive to the fact that the declaratory order it was being asked to put across had to do with actions that are void ab initio. Someone comes to court and seeks an order that the actions were void ab initio. There were nothing took place. Surely, a court must be very slow to send away such a litigant on the basis of seeking domestic remedies, because the whole attack was on what was happening. The same thing would apply to the Estoppel argument. I submit in the same manner that it was a discretion by the court, that the delay by the first respondent in bringing these proceedings was not such as would warrant a denial of a remedy for it. These are matters within the court. You can come after 5 years or 6 years or 7 years. There is a judgment by my Lord Justice Patel. I don't have it, maybe you remember, where someone was seeking condonation. I'm sure they came after 11 years. And he was able to grant condonation. It's a recent decision. I'm not sure whether it's 11 years, my Lord Justice Patel. But this was someone applying for condonation and extension of time. Some person who went to the DRC, an army person, and then they had all sorts of excuses for why they were not coming to court. But the point I'm saying is matters of discretion. If I may close by looking at the appropriate order. My lords and my ladies, this matter is not moot. The point that appears to have been discussed with my learned friend. What happened on 15 February 2018 was an illegality of major proportion. Now, a reference has been made to the third responding and has having moved on. With respect, my lords and my ladies, that cannot make sense to say someone moves on. They are prevented from taking leadership of the party, lawful leadership of the party, by a group of people that have arrogated to themselves the power to decide the welfare of the organization. It has a constitution, it has everything. And then you are prevented from assuming the rent. So how do you move on? Whatever you are doing is a reaction to the fact that physically you are unable. But if this court has to take judicial notice of what has been happening, because some of the facts are not before us, it is that there are two groups calling themselves the MDC. We have been in this court before. We were in the High Court on several occasions. We also have pending matters in the High Court. And the court can take judicial notice of that fact. When we last appeared here, I think my Lord Justice Garwe, you were presiding, when we were sent back to the High Court. This was a time when there was the appellants, they were appealing against a judgment by Justice Bere in Bulawayo. And then we were sent back to the High Court. We haven't resolved that issue. Which of these two groups is the MDCT? So as this group that is said to have held a Congress or that is led by the second appellant, it is just a group of people calling themselves the MDCT. In the same way as my client has a group of people calling themselves the MDCT. So no one has moved on. If there's anyone who has moved on, it would be the appellants. They've moved on away from the MDCT. The meeting that they would have held is a movement away. And I think that in this regard, as I address that point, my lords and my ladies, I would refer you to my heads. I've referred to the case of the Anglican diocese decision, which would be appropriate here. And that appears on, I think that would be paragraph 9 of my heads. There, in the paragraph 9 of my heads, I have cited the cases that are relevant. There, I think this dispute came to the court some 5 years later, when, if one looks at the diocese trustees thing, my lords and my ladies will know that at the time that this court resolved the dispute in the Anglican Church, Dr. Gunonga had followers and doing so many things. And then Archbishop or Bishop Gandia had also followers. No one is said to have moved on, and that language must be abandoned with all due respect. It's a split in a movement. It's a leadership tussle in a movement caused by failure to respect the provisions of the Constitution. And the courts are there to ensure that there's rule of law. And we cannot have people benefiting from their own wrongs. There is a principle of law that is well entrenched. You cannot benefit from your own wrong. So if it is agreed that the second appellant and his group of supporters overthrew the constitution of the MDC, and then they are rewarded by an assertion that my client has moved on, that would be contrary to the principles upon which the rule of law is founded. I would close on that point. So the order that I would propose, my lords, has to be guided by the case of Jealous Mawarire versus, I think it was Mugabe Eno. It's a 2013 decision. I didn't refer to it. I had not anticipated the question. In the Mawarire case, although it was not an appeal, the court exercised the power. By the time the court was approached, we were already outside the constitutional parameters for the holding of an election within the 5-year period. But the court was able to make an adjustment. If this court agrees with us as the respondents, surely it must exercise its powers, and those powers that the court exercises over the voluntary association, its power derived from Section 176, which is powers to vindicate the rule of law. That's why we are in this court. It's because of the law. We want the law to apply. We have a constitution, it has not been followed. If the court agrees with us that it was not followed, this court has the power to take us back to 15 February, but by moving us forward. In other words, we step on the shoes of 15 February. We have the third respondent as the acting president. Then we adjust that way. All things can happen in that respect. The court will not be interfering with the voluntary association. It simply orders the holding of an extraordinary congress within a short space of time, and thereafter the first respondent manages its own affairs. So the only orders we seek here is that the appeal be dismissed, with costs in our case on a legal practitioner and client scale to be borne by the second and the third appellant, and then an adjustment be made to the order so that the extraordinary Congress can still take place. The 5 years cannot be stopped, but the appellants were able to stop the movement of a democratic discourse. Those are my points, my lords and my ladies.
I put a question to your learned friend for the first respondent, and that related to, I'm not sure if it's factually correct, that there was a meeting, a Congress. I'm not sure whether it was annual or five-ennial, if there is such a word, quintennial Congress that took place in May or June, whereat Nelson Chamisa was, I assume, without demurrer, elected as president of, we may call it the MDC for now. What impact does that have on the necessity for this court to then address those issues, to address the issues raised by the appeal? Surely the matter has now become moot. Chamisa has moved on, Khupe has moved on. If you succeed, which party, which entity is she going to take charge of, the third respondent? What is she going to do? What is she going to have? Does she have any supporters to back her? It's a very pertinent question, is it not?
My lord, I want to answer you quite shortly on that one. The first one is that this order is not about the third respondent. It's not about Khupe or about Chamisa. The order relates to the first appellant, who was the first respondent in the court accord. And there is an entity called the Movement for Democracy. body, because a body corporate, it's not about individuals doing whatever they will be doing. So that order still cannot be moot. Secondly, the meeting you are referring to, we are aware of various meetings that various groups have been holding. It is a group of people who met wherever they met and elected the second appellant as their president. That has nothing to do with the MDCT. In the same way that whatever my client may be doing, which is contrary to the judgment of the court, would not be. The MDCT has been ordered by the court to hold an extraordinary Congress. That's the law as we stand. All what this court is asked to do is whether that decision can stand or be vacated on appeal. And our submission with respect is that that decision must stand.
And then what? And then what? Who does what? If the MDCT is to be convened for an extraordinary Congress by the third respondent, will it take either of the factions or many factions, any of the factions anywhere? Where will it go? What is the practical consequences vis-a-vis the future of the MDCT as a whole?
My Lord, it will take us clearly in the right direction. If we make the order, we simply go back to 15 February 2018. The first respondent, the first appellant, had members, had leaders, had people. You start from there. Once the order is made, it has only been delayed by the appeal. But before the appeal was lodged, preparations were already taking place to have the Congress. What this order does is that it simply reinstates the proper leadership of the first respondent. How it is going to be implemented, this court must assume that the law will be followed, because what this court has to do is to follow. They'll have to follow the Constitution as it stands in convening their meetings, and whoever will be attending ought to be members. The court must not assume that because things have happened because obviously things would have happened once the appellants decided not to follow the Constitution. Things would have happened.
I'll ask that question again in a different way. If the extraordinary Congress is duly convened by the third respondent, as you desire, will the outcome of that Congress be any different from what happened in May or June this year?
It will be different.
It will?
My Lord, with respect, it will be very different. It will be different in the sense that that meeting would be the first meeting since 15 February 2018 that would be in terms of the law of the country. All the meetings that have taken place have been unlawful. So now you have a lawful meeting, and the outcome would be unlawful. It is not for this court to determine. It's not about numbers. I think if I may want to address that issue.
Well, no, we're moving away. It's a question of mootness. It's a question of mootness. That's really what it is. Practicability is the key issue. We agree that legally, lawfully, constitutionally, everything should be done according to the law, according to what the constitution of the party itself provides. We agree with that. The question is, what practical consequences does it have? And if none, surely this matter is moot.
My Lord Justice Patel, this issue of mootness would have to relate to factual issues, which are not currently before us. For us to determine that it won't be practicable, we have to have sufficient evidence. We cannot rely on judicial notice and say that we believe that it won't be practicable. This appeal court must act on the basis of the facts before it. These facts were before the court. Here we are asked to determine the correctness or otherwise of the decision of the court. And this court would be totally within its powers to simply dismiss the appeal. And then the issues relating to this are matters of evidence which we are not at liberty to be able to do it unless the court wants further evidence. My submission is that it would still be practicable. And again, I refer to the Anglican Church case. There, the Chief Justice, or then Deputy Chief Justice, and this court said that with voluntary associations, they can be split. Those that are in the minority are entitled to call themselves the voluntary association if they are within the parameters of the Constitution. So it's not about number. That's not the issue. The issue is who is following the Constitution of the MDC. And I submit that in that regard, mootness must not arise at this stage, because the delay has been caused by the appeal, which they are entitled to appeal, and that the court has not sufficient material before it to say that this is moot.
Professor Madugu? Oh, thank you very much. Advocate Mpofu, do you wish to respond?
I do, my lord, thank you. My lord, let me begin by dealing with the position of the third respondent.
Yes, may I proceed?
Thank you, my lord. My lord, I invite the court to have regard to record 11 and 12. As to the facts, pages 11 and 4, as to the facts, paragraph 28,
We have quite a few papers before us, so sometimes it takes us a bit of time to get to those pages. 11 and 12.
Paragraph 20, this is the founding affidavit, and it is key. In respect of Thokozani Khupe, the former deputy president, who now upholds herself as the president of the Movement for Democratic Change Party after she purportedly held a congress around April 2018. This is what the court is told. Khupe does not dispute this. Page 12, paragraph 29. Second sentence, but if she's holding herself as the president of the political party I formed and belong to, such a holding must be set aside on the following grounds. Paragraph 29, the second sentence. This is the case presented in the founding affidavit. It must be set aside on the following grounds. Number one, I'm a Congress delegate as I represent Bokes Summit District and was never invited to the alleged Congress held in Blawa. Two, the fifth respondent, Douglas Tokarase Monzora, as the Secretary General, did not invite delegates, neither did he take minutes of the alleged Congress. My province, district, ward, and branch were not invited to that Congress. As such, in terms of the Movement for Democratic Change Party Constitution, no Congress has been able to fill the vacancy left by the passing on of President of the Movement for Democratic Change Party, Mr. Morgan Richard Trangraj. He says what Khupe has done is to move on and do your own thing.
Sorry, you're dealing with the question of mootness, I take.
Correct, my
Very
lord.
much.
Correct, my lord. Thokozani Khupe does not oppose this. And the simple rule of law is that what is not disputed in affidavits is taken to be admitted. But it does not end there with respect. At page 142. The paragraph at the top, I'm reading from the third line, page 142. It is on record that the fourth respondent left the first respondent and held her own Congress and participated in the just ended harmonized elections. The three issues there. The first is that she left the party. The second is that she held her own Congress. The paragraph, my lord, right at the top. The third is that she participated in the harmonized elections. (142). My lord, the third line, at the top.
that the allegation that she is moved on is made now by the respondents, then the now appellants. And she does not dispute it. At page 145, paragraph 21.
Sorry, Advocate Mpofu, before you move on, under what banner did the third respondent participate in the harmonized elections?
She's a political outfit, which is
What
different.
was it called? MDC or something else?
It was MDC something, but I'm not sure what it was called. It was a political party. At page 145, I'm advised it was called MDCT. MDCT, maybe it means MDC Togo. But I'm advised it was MDCT. And the court will note that there is no party before it called MDCT. Then at page 145, I've already indicated earlier on that fourth respondent is no longer a member of the second respondent. She decided to form a new party. The only issue that remains is the resolution.
Sorry, what paragraph again?
Paragraph 21.
On page 145. Oh, paragraph 21.
The only issue that remains is the resolution of our court case in Blaawai. Therefore, I will not comment on the issues contained in this affidavit. My lords, my ladies, my lady, these are vehement allegations of facts were made on oath. It does not become the third respondent to come at this stage not having responded to any of these allegations. And she now seeks positive order, a positive order from the court, which the appellants are not on notice of. What this really means is that the issues in respect of which a finding had been made by the High Court are moot as concerns the third respondent, Thokozani Khupe, and she can no longer benefit anything from those findings. There is a record which says she has moved on. My lords, my ladies, it is scandalous without responding to those arguments to seek from this court as a respondent any relief which says she must be considered to be the president of the first appellant. It would be the mother of all scandals. My learned friend refers to the judgment in Mawarire, which is of no assistance to the third respondent. In Mawarire, Mr. Jelas Mawarire approached the court, sought relief from the court, justified why he felt he was entitled to relief. In a split decision, the court granted him relief. So whatever was granted Mr. Mawarire is what he asked for. Thokozani Khupe cannot be granted anything that she has not asked for. Then there is the issue of the developments that have since taken place. It is difficult because the court will end up and has already received evidence from the bar on this issue. It's a bit dicey. It's a bit dicey, but I'll add to the evidence by indicating, although I'll make a point at the end, by indicating that Congress happened after an application to interdict it was made and dismissed.
I'm sorry, this is the Congress referred to by your learned friend, the first respondent, the Congress in May or June. Is that it?
24 to 26 May
2019.
2019. An application was brought to interdict it. That application was dismissed. It proceeded on that strength. But it may very well be that there are those other additional issues may need to be resolved in a different forum. I then move.
Your point about this Congress having been held despite an application to interdict it, are you suggesting that it has changed the complexion of the factual issues before us?
Totally,
And
my
please explain why you think so.
Totally, my lord. My lord, what happened was that on the strength of the judgments under appeal, an application was brought to interdict Congress. The contention being that Congress cannot proceed because there's a judgment of the High Court. An appeal was noted.
No, my question is, what happened there? What happened at this Congress? There was a Congress in June 2019.
And there were full elections, a full Congress.
That's what I'm asking.
You
need to repeat that position. Because
thank you, my lord.
it was placed by counsel for the first respondent. We're not sure if it was factually correct.
Thank you, my lord. My lord, what happened is that pure elections, in terms of the constitution of the first appellant, were held.
Sorry, which constitution? Are we talking about the same constitution
The
as
authentic
before us?
constitution.
The one before us?
The authentic constitution. Officials were elected. And first appellate is now led by officials who were elected in terms of those Congress processes. What was being raised in the High Court?
That's not the question that's being asked at all. You seem to be deviating from the gist of it. Full elections were held and officials were elected, including the president.
Including the president, correct?
And the question is, what bearing does that have on the mootness of this matter?
It really makes the point that the judgment of the courts has really become moot because the issues that it addresses have been overtaken by lawful events. Lawful events in the sense that there's been a Congress in terms of the Constitution, lawful events in the sense that an attempt to interdict that Congress failed in a court of law. So
But there have also been processes that also took place at the behest of the third respondent, Thokozani Khupe.
processes were, my lord.
There was also, as we understand it, a Congress.
She has had a Congress.
A similar process.
She has had a Congress.
So there have been two parallel processes by Thokozani Khupe and by MDC led by Chamisa.
They are not parallel, my lord, with respect. They are not parallel when you consider page 29 of the record. The founding affidavit says she has started a Congress which was convened and held in a manner which is not contemplated by the Constitution of First Appellant. So it is not a parallel process. If she wanted a Congress in terms of this Constitution, it had to be convened by Douglas Nonzora. It had to invite or have as part of its delegates Mashavira. That did not happen. So that's a renunciation of the Constitution of the First Appellant.
I thought the president of the party can also call or the acting president can convene a Congress.
My Lord, before you, you do not have the facts, the evidence which says it was Thokozani Khupe who called for that Congress. So it's a bit murky. But what is important is that whatever process she undertook is a process which does not answer to the Constitution. Whoever could convene that Congress had to call Mashavir and didn't call Mashavir. So it cannot be a process in terms of the Constitution of the MDC.
Yes, you may proceed.
I intend to deal with the question of whether there can be more than one president. The court will notice that Mashavira will be...
Deputy President.
Pardon, my Lord?
Deputy President.
Thank you, my Lord. The Deputy President. The first respondent, who's the one who brought the application, has made a concession before this court. He has conceded that there can be more than one Deputy President. And that is the end of the matter. The appeal ought to be allowed on the strength of that concession. It is not open to the third respondent to seek to put a contrary position on that.
I think so that we are all speaking the same language. Where does the first respondent make that concession?
He made the concession, my Lord, right in front of this court, before this court.
You're not referring to the papers?
No, he made the concession here, but seemed to make the point that but those have to be elected, which is a different issue which I'll deal with. But he's accepted that there can be more than one deputy president. Article 9 deals with the office of the president. That is the point that I've made. Article 9.2, Article 9.3, Article 9.2.1.1, Article 10.6.1 being the articles relied upon by Malene Trent for the third respondent. But this is the point that I want to make on his argument, which completely answers it. Those articles say, for instance, this kind of role will be executed by the deputy president. What those articles mean is that this is a role of a deputy president and not, for instance, a role of the Secretary General of the National Chairperson. Malene Friend then says, if that is what it says, it can only mean that there is one deputy president, because if there is more than one deputy president, which president executes those functions? And with respect, that point is unnecessarily specious. Article 9.14 says the president will assign functions. 9.14.
Page.
Page 56 of the Constitution. The President shall appoint deputies to officers of Congress from a pool of national executive members elected from provinces and other office bearers where such is provided for in this Constitution, and shall from time to time assign functions and responsibilities to various portfolios in the national executive. So he has the authority to assign functions. So if there are roles which require to be executed by a deputy president, the president has the authority to assign functions. He can say to this deputy president, you chair this kind of committee. So the fact that there are more than one does not change anything. Malene Friend then says there is a typographical error. Because there is a typographical error, there is no need for evidence.
Sorry, before you deal with that, Edward Mpofu, some of the officials who constitute Congress, I could be wrong, are not very senior people, are they? If you look at the composition of Congress.
Of Congress, some of them.
Some of them could be even officials at the provincial district level.
Correct.
And the 914 says the president can appoint deputies to those people. Am I right? If you look at the composition of Congress, unfortunately, I've lost a page here. I'll have to look at the 56.
Thank you, my Lord. Let us go to the provision, because it is restricted in the manner in which it is crafted. It says the president shall appoint deputies to officers of Congress from a pool of national executive members. So deputies are not being appointed from the generality of the party. It is from a pool of the national executive members elected from provinces and other office bearers. So the pool that is available to the president is a pool that starts at a certain level.
So it is a pool consisting of executive
National executive
members.
Correct, my Lord. If I may move to the...
Yes, you may proceed.
Sorry, before you move, you're talking about these functions being assigned by the president. If there's more than one deputy, maybe 2 or 3. The difficulty would be in the instance of where the provision which deals with the death of the incumbent president. And that specifically says the deputy president shall take over as acting president, correct?
Correct, my Lord.
Now, unless, as we have in the Constitution, the national Constitution provision as to who takes over when, in the event of there being two vice presidents or 3 vice presidents, how would that particular problem be resolved? If there are more than one deputy president, and the Constitution says the deputy president shall take over as acting president, how is that to be resolved?
Thank you, my Lord. That is what is then resolved by the National Council.
Article 18.
In terms of article, it is 990.
No, is it 18 or 19? 18. There seems to be some it's Article 18, but actually paragraph 19. Am I right?
It is headed Article 18.
Article 18.
The paragraph is 19.
But paragraph is
that is
19.
the one, my Lord. So that issue is resolved in terms of that provision. Now I proceed to the issue of the Constitution being a contract. Because it is a contract, if a party thinks that the Constitution does not properly reflect the agreement between the parties, they must seek its rectification. A court cannot say there is a typographical error. As the court will notice, this is an issue that was not dealt with in the founding affidavit. And with respect, that ought to be the end of the matter. But if the court has regard to page 153, it is actually page 154. First respondent attempts to deal with this issue in the answering affidavit in paragraph 16. She says, it however is illegitimate S added to the term vice president. Who added the S? Paragraph 16. 154, my Lord.
We're looking at the same page.
So he fails to deal with this issue in the founding affidavit. When the objection is raised, he says, no, the S is illegitimate, it was added by someone. Who is that someone? But my learned friend then says courts can make a finding that this was not the intention of the parties. It does so after hearing parties. Even when it makes a finding that this was not the intention of Parliament, the court hears Parliament in terms of Section 15B of the Interpretation Act. Section 15B of the Interpretation Act says in trying to ascertain the meaning of a provision, the court has the right to look at the material which was used in Parliament and can even consider the explanatory memorandum. So when the court then makes that finding, even on legislation, it is doing so because it has considered. Lord, may I ask for 10, 15 minutes? 15. As you please, my Lord. And this ought to have been done. Then there's this issue of my learned friend argues that the president cannot appoint his deputy. That with respect is an awkward submission. Even the national president can appoint his own deputy. But let us say there's only one deputy president, and the president dies, and the acting president becomes the president. Surely the acting president now has the right to appoint a deputy. But it cannot be argued that a president cannot appoint their deputy, because that is contrary to Article 914. The president appoints deputies to all officials. He can appoint a deputy secretary general. He can appoint a deputy chairperson. So the president has this power, and it is a power that can and will always be exercised.
I think the argument with Article 914 is that it is limited to those appointments where they are provided for in the Constitution. In other words, the argument is that it's specifically provided for in the case of the Secretary for Elections, I think. Is that right?
Correct, my Lord.
I haven't finished. And therefore, by exclusion, it cannot relate to all other office bearers. There may be other instances as well where it's specifically provided that the President can appoint deputies to that particular post.
Thank you, my Lord. The difficulty with that argument is that it only identifies the deputy to the Secretary for Elections. So if 914 was meant to only deal with that one office, it would have said so clearly. But what is clear is that 914 is an umbrella provision which is meant to cover instances that go outside that single instance, because otherwise there would have been no need to have 914 there. I then turn to the meeting of the 15th of February 2018. A look at the minutes of that meeting shows that the meeting had been convened before the death of Dr. Tsvangirai. It had been convened to deal inter alia with what is referred to as the noise in the cockpit. The parties were already at loggerheads because the issue was who of the three vice presidents becomes the acting president. So there was already that noise. So it was convened to deal with that issue and did deal with that issue, having been properly convened. I draw the court's attention, if I may, to page 121.
I don't think it's being disputed that it was convened before the demise of Dr. Tsvangirai. What is being contested is the agenda for that meeting. It's being argued by counsel, by Professor Maduku, that the meeting must have had an agenda. It couldn't have been to notify parties of the death of Dr. Tsvangirai if he had convened it.
Correct, my lord.
Right.
That is,
But why did the agenda change? His difficulty is that the agenda was essentially revamped without it having been duly reconvened.
thank you, my lord. And my lord, the submission that I make is that that is actually incorrect as a matter of fact. The meeting had been convened to deal with, because what had happened was Dr. Tsvangirai was out of the country seeking medication, and there was an acting president in the party. And the question was, who is the real acting president during Dr. Tsvangirai's absence and even before his death? So there were already noises over that issue. So the meeting was then convened to address exactly that issue. But just before the meeting, Dr. Tsvangirai then dies. But that agenda of the meeting did not change. In fact, it became even more important to address the issue. My lords, I draw your attention to page 121. Paragraph 13.6. It deals in part with that issue. So it was actually called for that purpose. The debate was in accordance with the agenda. As regards the question of whether first appellant was properly before the court, the decisions that have nothing to do with the applicable principle are being cited. Madzivire, Harold, Crown, those decisions are being cited. They're irrelevant. Both those decisions deal with a situation in which a company purported to sue without the resolution of its directors mandating it to sue.
Sorry, which case?
Both Madzivire and Harold Crown. What actually happened in Madzivire was that one of the directors had actually not received notification of any meeting on which, at which a resolution for the company to sue was passed. In Harold Crown, the person who actually deposed to the affidavit claiming that he was a director was actually a director in a different company. So he was not a director of the company that had brought the proceedings. The clear principle is that the court considers whether it is the party litigating and not some unauthorized official on its behalf. Now, you do not just allege that it is not the party litigating, it is some unauthorized official on its behalf. The authorities require that you place before the court a minimum of evidence. If you fail to place before the court a minimum of evidence, there would be no basis upon which the court can find that. And that exactly is the scenario that had to be dealt with in this matter. I turn to the question of domestic remedies. My learned friend refers to a decision which was set aside on appeal, the Moe versus Forest Commission decision. That really does not take the issue anyway. But ground number 8 says the court proceeded on the wrong basis, both factually and legally. That is an attack on discretion. Discretion will be attacked if exercised capriciously, if it is exercised on a wrong principle, if it is exercised on wrong facts. In this matter, the court said there were no effective remedies because the same people whose conduct was being challenged were the ones who would chair the appeals tribunal. It proceeded on a wrong factual basis. Its exercise of a discretion is invalid under the circumstances. I draw the court's attention to the judgment in Baskiti. In Baskiti, Baskiti challenged
Advocate Mpofu, where is the composition of the disciplinary, I mean not the disciplinary committee, you say
The
that
appeals.
you say that the first respondent should have approached some entity within the party to air his grievances and have them resolved. Which particular entity? And where is that
It is
set out?
it is the Appeals Tribunal, Article 14, pages 73 and 74. The relevant provisions, Article 14.2, which says any dispute over the interpretation of this Constitution may be referred to the Appeals Tribunal for a ruling, so that sets out its jurisdiction. At page 74, right at the top, then sets out the membership of that tribunal, the tribunal president, who is a qualified legal practitioner of at least 7 years experience, a member of the party, at least 40 years of age. Now, for a respondent who is placed before the court, an opinion done by a member of the party, which is contrary to the party, to then say he could not approach a tribunal chaired by a member of the party, is with respect duplicitous. B then says 8 other individuals of the party. 14.4 says the 8 other members of the party, including the tribunal president, are elected by Congress. So these ones would have been elected in 2014. They have nothing to do with the second appellant. So those provisions are with respect clearly sufficient, and the court had no basis for holding otherwise.
Do you have any further submissions?
My Lord, can I just ask for a minute, because I think in dealing with the submissions by my learned friend for the third respondent, I've touched on the submissions made on behalf of the first respondent, but I just want to go through and see if there's something that I've left out.
Very well.
I mean,
Very well.
Thank you, my Lord. Just 2 points. The first is that our first respondent made reference to Article 6.4.2.1, which says without J, which says without prejudice to the generality
Sorry,
of the
article?
powers.
Article?
6.4.2.1. It is at page 14. J, without prejudice to the generality of its powers, the National Council shall, J, to elect, reappoint, and reassign party secretaries defined in clause 6.5.3 of this Constitution, save those that are directly elected by Congress. That does not take the matter anyway. This is a specific power which deals specifically with secretaries. And it says for those secretaries, the National Council can elect, reappoint, and reassign, save those that are directly elected at Congress. So it says nothing about the subject at hand and does not affect it in any way. The second point relating to domestic remedies. This is an issue of fact. This is an issue that should have been dealt with in the founding affidavit. This is an issue that was not dealt with in the founding affidavit. But it is additionally an issue which is undermined by the fact that not only are there considerations relating to the exhaustion of domestic remedies, but the principle of subsidiarity and avoidance also comes to the fore. Zinyemba versus Minister of Lands. So he had two hurdles to clear. Number one, the fact that he had not pursued the remedies provided for under the Constitution. Number two, the fact that he was activating a constitutional protection over a contractual matter. This is a contractual matter. This is not a matter that required the activation of the Constitution of Zimbabwe, 2013. So on those two grounds, first respondent was out of court. On those two grounds, the application ought to have failed. He now cannot purport to ask for relief that he was not granted. At best for first respondent, if the appeal is not merited, it simply does not succeed. But he cannot, he has not done so, he has not put the appellants on notice, he cannot purport to ask for any additional relief. My lords, my lady, those will be my submissions in reply.
Thank you, Advocate Mpoka.
My lord, member.
Is there another burning point you wish to make, Advocate Mpoka?
My lord, I'm actually being advised that the Constitution actually prohibits an extension of Congress timelines. And so first respondent would not be able to seek that relief. It would be in violation of the Constitution at any rate.
You're able to say in terms of what article?
Thank you, my lord. Having my attention drawn to Article 6.2.3 G, as read together with Article 6.2.
Article 6.2
.3 G,
G.
page 12.
6.2.3.
Now, 6.2.3 G says Congress can condone any reasonable non-compliance with the time limits provided for in the Constitution, but cannot condone a departure from the time limits set out under Article 6.2.2. Article 6.2.2 deals with there being a need for a Congress every 5 years. And that Congress has already taken place.
Article 6.2.3 G, and then the other one that you referred to?
Is 6.2.2.
6.2.2. Ah, okay, all right.
So your point is this, the quintennial Congress cannot be deferred
Correct, my lord.
beyond 5 years.
Beyond 5
obviously.
years.
Yeah.
Correct, my lord. And it has already been
In June. This is the one in June.
In May.
May 24, 26 May.
Yes, anything else?
Lord, I have no further submissions to make.
Thank you. take this opportunity to thank counsel on both sides, Advocate Mpofu, Mr. Mtungura, and Professor Maduku for the submissions that have been made before us, which submissions we are going to take into account in coming to what we consider is a proper determination of this matter. So thank you very much. Obviously, we're not in a position to give a determination immediately, so judgment in this matter is reserved.
This is the end of today's rule, my lord and my lady.